You don't want to be held legally responsible for somebody else's screw up. That seems like common sense, but let me put it into a real world situation that maybe sounds a little more familiar. A patient comes into your practice and they've treated with somebody previously. Now they're coming to see you for retreatment of the same problem. Maybe the previous treatment didn't fix the problem, or maybe even worse, it actually created new problems that now need to be addressed as well as the original problem. And as you talk to the patient, it becomes clear, unfortunately, that the treatment they received from the previous provider did not meet the minimum standard of care. So now you have a dilemma. You want to help the patient, but you're in a tricky spot because you don't want to be on the hook legally for problems that were caused by somebody else's treatment. Obviously, you only want to be held responsible for the treatment that you yourself provided. So, what do? Do you tell the patient you can't help them because you're just too nervous about the legal liability issues? Or do you just blaze forward and help the patient and hope for the best? Fortunately, there's a way to chart a path between those two extremes. You can help a patient and still mitigate your own potential legal exposure in this situation. All you need to do is know a few best practices, give it some forethought ahead of time, plan accordingly, and you can accomplish both of those goals. If you're more interested in that, let's jump in and talk about it now. Hey, Tooth Nation, I'm the Orthattorney, Trey Lawrence. I've been in practice of law for over 20 years, and I'm general counsel for the American Association of Orthodontists. The Orthattorney brings you important legal information about topics that are essential, relevant, and hopefully at least mildly entertaining. If you find this information helpful, please check out the Orthattorney on our other social media platforms, Instagram, TikTok. I'll leave links in the description below. If you found the information in this video helpful, please crush that like button, hit the subscribe button, ring the notification bell so that you can get notice every time a new video comes out from the Orthattorney with information about legal topics just like this. And as always, if you found this information helpful, please share with your other practices, your other friends that you know, so that you can get the word out and they can take advantage of the information from the Orthattorney as well. And then finally, all the legal blah, blah, blah that I have to say, the information presented by the Orthattorney is not intended to convey legal advice. It is not intended to constitute an advertisement for legal services, and the Orthattorney strongly encourages you to consult with an attorney that's licensed in your state and jurisdiction before taking action on any subject that could potentially incur legal liability for you or your practice. Care that doesn't meet the minimum standard of care is, unfortunately, as everybody knows, just a reality in any kind of practice, and certainly dentistry and orthodontics. In my particular corner of the dental profession, the orthodontic specialty, that problem is unfortunately acutely present in the form of orthodontic treatment that you can put in a box, companies can put in a box, ship to a patient's home, and the patient do their own orthodontic treatment without ever going into an office to see the person who's overseeing their treatment in person. And unfortunately, no matter what the context within the dental profession, patients can be harmed by substandard care, and they need retreatment to correct that harm. So that's where we come back to you. When that patient comes in, you want to help that patient, but you're also concerned because the patient now has some problems caused by that substandard care and you don't want to be legally responsible for them. Let's talk about 3 pointers to make sure that you limit your own exposure but help that patient out. Number 1, take exhaustive intake records and imaging. So as we said, you don't want to be held legally responsible for the problem that somebody else caused. And the good thing is that the law is with you in that respect. The law is not going to hold you legally responsible for problems somebody else caused. You are only legally liable for harm that you proximately caused to that patient for your own treatment. So the issue then becomes, how are you going to demonstrate that the harm that a patient is complaining of, whether that's a lawsuit, a malpractice lawsuit, or a dental board complaint, you have to show that that harm was caused by the treatment they received from somebody previously and not from the treatment you provided. So how are you going to make that showing? The key to that is going to be the set of records and images and notes, patient history, all of that information that you gather when the patient first comes into your practice. Now, here's another piece that complicates that even further, is many times when the patient has had a problem with the previous provider, they're not going to be bringing their records from that provider with them. Maybe the provider refused to give them in the first place. That's certainly what we see with some of these mail order companies. It's incredibly hard for patients to get their records from those companies. or maybe the patient just doesn't have them, or maybe the patient just needs to get started right away to correct the problem. You don't have time to ask for them. So you need to create your own evidentiary record. And what that means is you need to take the fullest, most thorough set of intake records, notes for yourself, patient histories, and imaging that you can possibly take. This is a situation where you want to use every tool in your toolbox to document the patient's current condition, as well as your assessment of the risks, your assessment of the current conditions and problems, and then the treatment going forward. You want to document all of that as thoroughly as possible in as many ways as possible. That means your own notes, that means the patient case history, and that means imaging, every kind of imaging that you can take. I would do it all in that situation. That's what's going to give you the best opportunity possible if there's a complaint down the road to demonstrate where the harm originated from, not from your treatment. Now, there's one other thing that may complicate this. You may be one of those practices that's very big on same-day case starts, starting the patient as soon as they come in, on the same day that they come in for evaluation, to get their treatment started. And I absolutely understand all of the business reasons for that. When patients walk out the door before they start, there's a higher likelihood that they won't actually carry through with treatment. There's efficiency considerations. I get all of that, but in this situation, this may not be the case to do that on, because you're going to need time, first of all, to make sure you have the full set of records and documentation that you need to defend yourself later if it becomes an issue. And number two, this may be a case where you need to give a little more thought to planning your strategy out, making sure that you're thinking of every angle that could be caused by the substandard harm that they received, or the substandard care they received previously before they came to see you. So this may not be the case to focus on as a same-day start. Normally, yes, this one, maybe give a breather, give yourself a day or two before you start treatment. But in any situation, take thorough records. Number two, use the informed consent process as a tool to manage the patient's expectations in this situation. So if you follow the Orthattorney on social media, or you watch any of my videos, you're going to quickly hear the soapbox that I repeat over and over again. Informed consent is a process and not a form. So in any case, whether it's retreatment of a substandard care case or generally, you need to be having the patient have an opportunity to directly interact with the doctor at some point in the informed consent process. I know many practices have their treatment coordinator or somebody else handle informed consent. That's fine generally, but you have to give the patient an opportunity to invite the doctor in and ask questions. Tell the patient, would you like for Dr. Smith to come in? And do you have any questions for Dr. Smith before we start? That kind of thing. Certainly, the just sticking the informed consent form in a pile of other papers that are handed to the patient to fill out and return, or doing it online, or just fine print online, that is not the way to do it. That's in any case, because informed consent is all about the patient understanding the limitations and risks of their treatment, and then making a decision to move forward with treatment, knowing those risks and limitations. That is incredibly true when you're retreating a case that received substandard care previously, because a couple of reasons. Number one, it may be the case that what happened previously limits the amount of treatment, or limits the result that you can provide to the patient now. So maybe because of something that happened previously on this case for this patient, you can only give an 80% result instead of 100% result. Well, that is something that you need to communicate clearly to the patient and make sure that they're aware of that before they agree to move forward with treatment. Informed consent is the time to do that. Similarly, if there are increased risks that have been brought about by the substandard care that they received previously, that wouldn't normally be there, then you need to use the informed consent process as the opportunity to raise those risks with the patient, make sure they're aware before you move forward with treatment, so that later they can't say, well, you didn't tell me, I wouldn't have agreed to this if I'd known that. That informed consent process is the perfect vehicle to allow you to have those conversations with that patient. And certainly this is one of those times, if your treatment coordinator normally handles informed consent for you, I would highly recommend that you, the doctor, handle the informed consent process in this situation. Because of the increased, there's higher risk going forward. You want to do everything you can to manage that risk. This is one of those ways. And finally, even aside from any legal liability type of issues, it's just good PR. It's just good case management to make sure that the patient's expectations are realistic and that they know the risks, that's going to ensure a much better chance of having a happy patient at the end of treatment, no matter what happens. So again, informed consent is just a natural vehicle. It's just a natural opportunity to accomplish those goals, even aside from the legal issues. Number 3, exhaust all efforts to get copies of records from the prior provider. Like I said, these may be the cases where the patient is not bringing the records with them from the prior provider for a number of reasons. But it is especially important if you're going to document the condition that the patient was in when they first presented to you, which means the condition they were in because of somebody else's treatment. That set of records is going to be the most crucial tool to communicate that, to paint that picture for a judge, a jury, a dental board down the road. Therefore, it is essential that you get those records from the prior provider. And again, maybe for many reasons that may be going on related to the situation, that may be difficult to get those records. Multiple phone calls, multiple emails to that practice, whatever you need to do. If you still can't get a response, send a letter, maybe even send it certified mail, return receipt requested, so it looks all official. But at the very least, if you're trying to defend yourself later in a court or to a dental board and you don't have those records, but you want to at least demonstrate that you exercise due diligence, try to get them, that letter to the practice is going to be a crucial piece of evidence. That's going to be much more compelling to show, no, I wanted those records because I wanted to document the bad shape that the patient was in when they came to see me. I tried to get those records. That letter is going to be much better proof of that than just saying, oh, we made phone calls, or oh, we typed emails, or that kind of thing. So every effort that you can undertake, get those records from the previous provider. So challenging retreatment cases, substandard care previously. Yes, there probably is a higher legal risk to you, but you want to help that patient out. And there are ways, there's best practices that we've talked about to manage those legal risks, to mitigate the risk and lower your own exposure in these situations. So how has your practice handled these situations? Have you had those patients come in? Were you just too nervous to take the case? Did you do the just treat the case and hope for the best approach, or were there steps that you took to manage your own risk in those situations? If you've been in that situation previously, leave a comment below. Let me know how you handled those situations. So Tooth Nation, I'm the Orth Attorney, Trey Lawrence. Again, I hope you found the information in this video helpful. If you did, crush that like button, hit the subscribe button, ring the notification bell so you get noticed every time new videos just like this with information just like this comes out, and hopefully can continue to be of assistance to you and your practice. Until next time, Tooth Nation, be good, stay out of legal trouble, because being sued bites. See you next time.